Call to order the meeting of the Michigan Board of State Canvassers. You turned it off. Okay.
It's not working.
The first item on our agenda is public comment. Has anyone asked to speak?
Mr. Gallen has asked to speak, but he is not logged in yet. Right,
So the next item on our agenda is consideration of the meeting minutes for the January 19th, 2024 meeting.
Make a motion that we approve the minutes of the Board of State Canvassers meeting held on January 19th, 2024.
Second.
All in favor?
Aye. Aye.
Aye. The motion carries. The next item on our agenda is recording of the results of the special primary election for the office of State Representative 25th District. Director Brader, do you have any?
So this was a special primary election that was held in the 25th district for State House. Because it is entirely within Wayne County, technically the board is not certifying this, but rather recording the results of this. The board will certify the other State House race because that one crosses county lines, and so it falls within the board's purview to certify. But in this race, in House District 25, we had a total of 6,026 votes cast. And I'm sorry, I'm just pulling up what number is the result? 0.2. Sorry, I had the wrong file open. And so in this race, sorry, I'm at the wrong page. I apologize. That's the 25th. Okay, sorry, I apologize. So there was no contest on the Republican side, right? Just one candidate. Yeah, so there's only one candidate on the Republican side, Josh Powell. And he won, unsurprisingly, with a total of 2,117 votes. And then on the Democratic side, the winning candidate was Peter Hertzberg with a total of 2,034 votes.
We have a motion?
I move that the board record the results of the January 30th, 2024 special election, primary election for the office of State Representative 25th District as certified by the Wayne County Board of Canvassers on February 7th, 2024.
Support.
All in favor? Aye. The motion carries. The next item on our agenda is certification of the results of the special primary election for the office of State Representative 13th District. Director Brader.
So in this race, the winning candidate on the 4.2. Oh, oops. Sorry, give me a second. So in this race, the winning candidate on the Democratic side was Mai Zhang, who had a total of 3,476 votes in Macomb and 459 in Wayne for a total of 3,935. And on the Republican side, the winning candidate was Ronald Singer, who had a total of 1,068 votes in Macomb and 10 votes in Wayne for a total of 1,078.
Do we have a motion?
Trying to find it, sorry.
I'm trying to.
It took me a while, but I'll do it. It's okay. Based on the examination of the returns received by the Secretary of State for the January 30th, 2024 special primary, I move that the Board of State Canvassers certify that the attached report is a true statement of the votes cast at the special primary for the offices certified by this board. I further move that the board certify that the persons named in the following list of nominees are duly nominated for the offices indicated and are qualified to appear as candidates for such offices on April 16th, 2024 special general election ballot.
Support.
I'd like to make a further motion. I move that the Board of State Canvassers authorize the staff of the Bureau of Elections to represent the board in any recount of votes cast at the April 16th, 2024 special primary election.
So we have two motions.
Sorry.
Yeah, on the first motion for election certification. Do we have a second?
Yes, I support. that.
Okay,
Sorry.
okay, all in favor?
Aye.
Aye. That motion carries. And the second motion is with regard to the any recount. Do we have a second on that motion?
Seconded that.
Okay, so all in favor?
Aye.
Aye.
Okay, the motion carries.
Sorry to rush that.
Okay. The next item on our agenda is consideration of proposed legislation.
Yeah, so I'm gonna hand this to Adam to talk about. I was remiss in the last agenda item, though. I do want to just convey my appreciation to both the municipal and county clerks in Macomb County and Wayne County for conducting the special primary. There's obviously a lot of extra work to have the special primary on top of the presidential primary, which is upcoming. So they put a tremendous number of hours into that, and obviously, you know, communicating with voters, helping them understand that there were multiple elections going on. And so I think the clerks did a great job, and I just wanted to point that out. So with that, I want to hand it to Adam to talk about the legislation.
So as the board's aware, we've been undergoing review of the petition process for a little bit now. When we had a couple of meetings ago, we've had some discussion about changes that could be made to the law to just further clarify the process and in general, just to update election law as far as processing petitions to reflect a lot of the board's decisions, legal cases against the board that have been that courts have issued really for decades back, that is the practice for the board, but doesn't necessarily isn't necessarily crystal clear in law. So what we did was essentially put pen to paper with the petition sections of the law. It's quite a lengthy section. And I'm happy to walk through any part of it that the board would like. But in general, when I was going through this, the goal was basically to clarify the statutes and ensure that what is practice right now, because of court orders or interpretations that have been issued either through like an attorney general opinion over the years, a court order, or a board determination, really is reflected in the law. And similarly, went through and updated the statute to remove provisions that are outdated. So the biggest example I can say is there was an amendment in 2018 to the petition process, to the petition forms themselves, mainly to require 15% from each congressional district. The Michigan Supreme Court struck that statute down, and it's still reflected in the law. We've tried to clarify exactly what those requirements are based on those types of things throughout here. So I'm happy to walk through individual sections if the board has questions. I'm happy to kind of take this however the board would like. There are two things here that I do want to explain. We do have, when we talked about this the first time, Member Daunt had expressed that it may be helpful to see it in an LSB format. So that's the version that you have that version in front of you as well. It's the same version that's online. The only difference is that it's in LSB format, how they do it versus track changes in a Word document. But the second piece, it's in your packets as agenda item 5.3, is LSB thought that there would need to be an amendment to the Constitution in order to change the filing deadline for petitions. So you've got both of those pieces. We, in the work group, when we talked about the filing deadline, I think as everybody probably agrees, there has to be some adjustment to filing deadlines for petitions. They're extremely close, and with everything else that has been put into place, it's getting a little bit into crunch time where we're reviewing petitions and having to certify and not giving courts enough time to really review and things like that. So that's that piece with the filing deadline. And I guess with that, if there's any questions, I'm happy to answer any questions the board may have. Yeah.
I'll just clarify for the record that Vice Chair Housecamp and I met with many of the practitioners and with Director Brader and Mr. Fracassi to get input and give input. And it was very helpful, I think. And the suggestions that were made have been incorporated here along with others that staff found necessary, as Mr. Fracassi stated. Any questions?
Yeah, I think so. I understand the a significant chunk of why we're doing this, what's helpful. Obviously, the filing deadline and giving more time for things to be reviewed and adjudicated through the courts without a rush on them. I think even that's obviously a bipartisan type issue. The thing that stands out to me is just and I don't think it's a fatal concern, but the issue of moving from strict compliance to substantial. And to me, that opens up for a lot more interpretation, and I don't want to say gamesmanship, but attorneys are paid to advocate for their clients. And oftentimes when we have these difficult calls before us, having the strict compliance in place makes it easier, and it's not, our decisions aren't colored by any other consideration than exactly what the law says. And so what do you guys have concerns of how that might further muck up or delay the process by moving to that substantial as opposed to strict? And what are some things that could be a little more difficult to make a call on in your experience?
Yes. From the Bureau perspective, and Adam, I think you should probably add to this as well. I think, there's a reasonable argument for either a substantial compliance or a strict compliance approach. The benefit of strict compliance, which we've been operating under, is that it does tend to simplify some of the review of some of these petitions. You can still always argue whether something strictly complies or doesn't strictly comply if like part of a letter is torn off or something like that. But generally speaking, we are able to complete a pretty standard review of everything and present it to the board. The major downside there is, the board many times, and Bureau staff as well, have the experience that we are recommending to reject, or the board is voting to reject, a petition where nobody really thinks that the issue that was on the petition is something that would have actually confused people signing it or would have actually made a material difference to the individual trying to submit the petition for whatever purpose. So the substantial compliance does allow the board, the Bureau, to make recommendations, which we'd be comfortable making, and the board to consider recommendations to determine whether or not this is really the type of issue that actually made a difference. I think, we could, and there's a previous practice to rely on from before the court decision, Stand Up for Democracy, that moved us to strict compliance, that we could lean on and come up with some general standards that the Bureau would follow and that the board could consider in determining whether something substantially complies. I think, I'm confident the Bureau could still present things in an objective way under a substantial compliance standard. We can obviously consider board discussions and make adjustments to our recommendations over time based on how the board handles certain petitions. So it may make things a bit more complicated for us, but it also may allow both the Bureau and the board to consider, in the future that the decisions that they're making are more based on the actual effect of some of these issues as opposed to what sometimes feels unfair under the strict compliance standard. Adam, I don't know if you have anything to add to that.
No, I actually, Jonathan said everything that I would have said as well. I think there's those two sides.
Just a question on the heels of what you just said, and to Mr. Dodd's question, is it reasonable to assume that if we go with if the substantial compliance goes into effect, would that then become a series of meetings here where we're reviewing, or somebody argues about what's substantial and what's not, and it becomes like a funnel where meeting after meeting after meeting, we're making little determinations, and eventually over a period of a couple of cycles, substantial compliance is not returned, but strict compliance is not returned, but substantial compliance is really based on a bunch of precedents that were made by decisions. Is that kind of the pattern you see emerging?
Ideally, that's what would happen. I mean, we would come up with sort of a rubric for what types of issues, would be standard versus not standard compliance. And we would obviously look back to the extent we could on past decisions from the board. And then the board would develop its own precedents, which we would then incorporate in the guidance. And then I would be very surprised if there were not some court cases resulting from the board's actions where the courts might give us more guidance in terms of how to interpret the substantial compliance language, which the board would then, of course, apply. So I do think over time we would develop a more detailed precedent that would help future boards make those decisions. That, of course, I don't anticipate that would prevent us from having arguments from lawyers at these hearings, but we still are having those now. So, even with strict compliance. So I'm not sure whether it would be more or less time.
So potentially this would give you a more dynamic, a more organic system where it might strengthen the ability for the board to review and for people to present to the board. You don't have a rubric that you've thought through at this point, I don't think, do you? You don't have a list of what's substantial and what's.
I don't think we've developed that at the staff level. I mean, as I said, I think there would be some things as starting points based on what the board had previously done. But other than that, no.
I would note that changing to substantial compliance is really returning to what was the interpretive method prior to the 2012 case, Stand Up for Democracy. That was when the Michigan Supreme Court interpreted the statute to require strict compliance. Substantial compliance had been the order of the day for decades prior to that. So it's really returning to the long-term practice of the board. I did discuss this with Chris Thomas, who people know had been the elections director for 30 years. And he certainly encouraged us to use a substantial compliance standard. And that was one that was supported. The use of substantial compliance was supported by practitioners from both sides. Remarkable, right? Remarkable agreement on that one. So I think, I don't think that it will be particularly difficult. I mean, one of the things that strict compliance has required us to do is to reject a petition which has only, poor copy and is missing an immaterial word. So I think that this will be fairer to the people who are using the petition process.
Question of legislative process. Let's say this moves forward and the legislature passes it. You had mentioned that there's a need for a constitutional amendment for the filing deadline portion. That obviously wouldn't happen anytime soon, unless they did it right away, I guess, and then it could be on the ballot this cycle. But either way, even without that passage of this, this wouldn't take effect until the next go round, correct? I mean, I guess unless they got immediate effect, but.
Yeah, I would say it depends. Typical lawyer answer, it depends. So the legislative, one thing I should have said is that this is very, very early with the process. This is not, what you have in front of you is not a final version or anything like that.
They're not gonna pass
so-
this next week.
Right. So if there's still changes that really anybody wants, there's the public hearings and things like that for that. From there, it would, it depends on if it gets immediate effect in the Senate or not. I probably wouldn't recommend, even if it were to get immediate effect, I wouldn't recommend doing it like right now. We're in the middle of a filing cycle right now. So I would probably recommend personally, like 2025, January 1st of 25. Typically the board's practice is even when it's internal decisions, they don't want to change something mid-cycle, change something that would affect, especially when there's petitions in the field or anything like that. So I would recommend for that reason the same. And I don't think I'm personally not sure on whether or not a constitutional amendment is needed. I will defer to kind of what others, I guess, on that think. But I think even if the deadline doesn't get changed, we obviously would really like it to be. I think the other pieces that are in that, just the clarity pieces and just putting into statute what we're already doing, like what the court has ordered, and even just putting those pieces in, I think would still be helpful both for us at the bureau level, the board, and also candidates and voters.
Director Brader mentioned when he was discussing this, the ability of putting together some guidelines and kind of examples of what is substantial, what is not. I think that would be very helpful too for us, you know. And I remember that the issue that Chair Gerwitz brought up of the individual running for office, and there was just this very minuscule issue missing, and none of us wanted to vote to reject him, but we had to. And so that certainly, in that instance, this makes sense. In an issue where you've got kind of an obvious error, and now the carelessness is opened up for an escape hatch with substantial compliance, that's where I have a little bit of hesitation. But if there were some guidelines in place and this didn't take effect until 25, in that next process, I think that these answers address and put some of my concerns at ease.
And I have to, I agree with Member Dawn, because as much as it is difficult to take the vote to remove someone off the ballot because their petition does not meet the form requirements, it's still the form requirement. The requirement of the form is still there. I guess that's where I understand, and I'm listening to the Bureau. I mean, having been on this board of just strict compliance, I will say that it doesn't make the vote easier, but it makes it's laid out pretty darn clear. Like, if you are missing this part of the form, and yes, I know it's horrible if you made a copy or whatever when you did your petitions and you're missing like that little edge line, but it does make a difference because it doesn't hit the form. I guess that's where I am a little bit of, being a board member, being here the entire time that it is strict compliance, it does give us exact, clear lines, what is acceptable, what is not acceptable. And the fact of like, where my concern is, okay, so I understand getting guidelines, but we've been doing this the entire time of trying to get guidelines on recalls and wording and how we do this. And it's, if we're talking about changing the legislature, if we're talking about changing law, I guess I understand like how that is, going back to before, but I also understand that we're in a different period than we were before 2012. We have different issues coming before this board that we haven't had before 2012. And so I'd like to know more. I'd like to know more of the Bureau, of where you're sitting on that and what that means for staff, what that means for us. So that's kind of where being the person who's been here longest and who's stuck with, has only had strict compliance, like that's where I'm a little bit hesitant to say, okay, yeah, let's go to substantial. Like that would be great. But there's also that part of it is, if you're petitioning the government, there are requirements. So I'm sorry, I was trying to listen to everybody and understand, but I'm hesitant on that one for me.
Well, yeah, I think what we would do, I mean, obviously it would depend on what was in the legislation that
Right.
were enacted. So we would, of course, look first at the language of the statute, and that might have some further detail there. From the Bureau standpoint, I don't necessarily think it would make a huge difference for us in the timing of our review. Initially, it would take some time for us to develop and make sure we had a consistent process for determining if something met the statutory standard, if it were substantial compliance. But I don't think, as a factor of like the total amount of time that we spend reviewing things, this would make a major difference for us. I think it would more, at least at first, the first few hearings that the board held to review specific petitions, that's probably where we have the most difficulty or we wouldn't exactly know what to expect until the board sort of dug into some actual petitions and we tried to apply our standards to them. But I think the board could navigate that, but that's probably where the biggest challenge would be. Do you have anything to add to that?
I would, I would say, I think that you could even, if you could even provide parameters in the statute about what is substantial compliance. I think there's a difference, and I think member Don said this as well. Like, I think there's a difference between something that is material to a voter versus not, like that the voter would see. The example that I can think of is that in 2022, the board disqualified a candidate for a congressional district because the individual put stickers on the heading. And the person did this because of penmanship and wanted to make sure voters knew. But the unfortunate part is when they put stickers, it ended up covering up not even the statement in the heading, the word underneath the line. So like in that instance, that's not necessarily, like, you could define the statute to say that it's substantial compliance means X and give a little bit more parameter to it and say it's not a material. That's different than if the entire heading of the petition is lopped off because of a copying error and you don't know what candidate it is, what the office you're running for. Like, so I think that's the two sides. So that's what I would say. If that is a concern, you can further narrow down, like, this is what substantial compliance means. It must be substantially in the following form, and then say substantial compliance is defined as X or whatever that language is. That way it still gives the flexibility for those immaterial things that, like, that little bit of the T is cut off, but we all know it's a T and voters could reasonably look at it and think it's a T, versus I've left off the entire, when we copied the petition sheet, we went from an 8.5 by 14 and to an 8.5 by 11, and we cut off the entire date of signature. That's like the two sides.
I think that's something that I'd rather see a little bit more, if we can, in language. Because like I said, we're seeing a lot of different things, sorry, I've been on this board for 10 years, so I've seen a lot of different things come in, but in the last years, there has been a lot of different things coming in. And so I'm afraid to just let that open without having something already there.
One of the things that I've noticed in Director Brader's comments and Mr. Fracasse's is that they both use the word material or immaterial, the same thing. And that's, I think, what we're talking about with regard to substantial compliance. Is any deviation a material deviation, or is it something which really does not affect the petition, the substance of the petition?
But I still have this, it's slop, I don't want to say it's sloppiness, but it's rushing. It's not following, when you're signing, I've said this all the time, when you're signing a legal document, you want to make sure that that legal document is correct. Right. And I know about that sticker one, because listen, my penmanship can be awful sometimes. But you still have to follow the rules. This is where I'm sorry that I'm struggling. Maybe I just.
That's a legitimate struggle.
Yeah, it's like if you open the box, how far are you going to open the box up?
Creating an enormous opportunity for billable hours.
I think we've
He's the only attorney here. But, it's clear that we have had these arguments about whether there's strict compliance, just as we would have an argument about whether there's substantial compliance. I think a creative attorney can make that argument regardless of what standard we have, can and will. There's a case that I had that really sticks out in my mind where I was representing, I think I've mentioned this to board members, excuse me. I was representing a judicial candidate, and the board, or excuse me, the staff recommended that he not be put on the ballot. He had used an old petition form, and the Bureau had issued new petition forms. And he went to his county clerk to get petitions. She gave him the old forms. She said she didn't know that there were new forms. She had not paid attention to what was sent to her. And so the Bureau recommended, I think reluctantly, that the board reject his petitions. And the board did not.
We did not. I was there.
Right. And it was an argument about strict compliance. He was using the wrong petition form, but he had done absolutely everything
But
that he was supposed to.
right,
do.
and that was our argument, though, is that he was using a form that was approved at one time. And so it's not, that was the conversation. It wasn't like, here's this form and I made a mistake on the form. And so, but you guys should let me on the ballot because I didn't mean to make the mistake, but it doesn't mean anything because it's just this little material mistake. But like, that's where I kind of am. And I'm listening, but I'm also, I just have a general concern. I think just being here within the current atmosphere, I just have just a little bit. I'm not no, but I'm just more, how far are you going to open that up? And it's a good one. It's a good case to say, but we did have the gentleman who, I don't know what number that was. I don't know what date that was on there. On the upside. Well, if you look at it upside down, then it looks like a 2 and it might've been a 3. I just see that that's going to be the standard going forward, is we're going to have these constant meetings in between listening, that you're that's where my concern is. Instead of saying, look, this doesn't meet the form and it doesn't meet the requirement. And I can see where we could have some kind of, leeway, but I'd like to have a little bit of that leeway kind of already there. I'm before So that there's something for those members who are here on this board. That it's not just relying on the opinion of clever lawyers, I guess I should say that.
One thing for us to consider is that this is a recommendation to the legislature. And they will do what the legislature does. They'll pick it over. Also, the elections committee, probably in each house will be looking at this, and will be getting input from sources other than ours. There will be people weighing in on,
They don't normally
On
come to
these
us and ask us
changes.
what we want. They normally just change it. Then
right,
bring it to
so,
us.
I mean, this is,
Yeah,
it's a recommendation. They'll decide whether or not they agree with what we're recommending. But I'm not sure that we agree with what we're recommending. So,
it's not that I don't, it's just, I have some concerns. That's where I'm at. And I think it's just concerns out of sitting on this side and having those issues come in front of us. You know, that's where, and it's not like I wouldn't vote no on the motion. That's not, like, that's kind of where it's more of, let's have a conversation. Like, I just want to listen to more of what it is, so.
If I can go back one step, when we first started talking substantial compliance versus strict compliance. I'm getting this recollection that we walked through it because we were dealing with how to shorten workloads, how to shorten or help timeframes at a point where we were deciding whether we could statistically look at things or whether we had to look at every single form. And the substantial compliance, I think, grew out of that discussion, didn't it? And it was more or less done. So the idea that it would maybe shave some time off of processing petitions and getting them, but we've gone with the statistical. And so, is there still a need to put the substantial in there?
I think it kind of grew more from like that's how the work group initially started, and then we just kind of evolved into, if we're going to be opening up the statute, what would be the wish list that the board would want? Blank canvas, things like that. I think both, like the arguments for it and for strict versus substantial both make complete sense. So personally, I think that if this is just a recommendation to the legislature, so I think you could take that piece out if you wanted to, or I'm happy to draft something and circulate language and we can discuss it again. And see if that's, something that like has a more narrow definition, whatever the board would prefer.
Is it possible? Because I know, obviously a good chunk of this is getting in compliance with court decisions and extending or, giving more time. And I think that's important. I don't think any of us want to, we're not trying to belabor this issue. I think there is genuine concern about kind of opening up into this even more of a Wild West. With the motion, is it possible to word through the motion? Basically we're supportive of moving this process forward with the understanding that the issue of moving to substantial compliance needs additional discussion and guardrail work, not sure how exactly to word it, but is that sufficient for you guys, and then also for my fellow board member who's got the same concerns?
I think that if the board makes its will clear in a motion that it wants that issue to be further considered and defined, that's something we could probably convey in like the cover message to the committees or whoever the legislature would send this to. So that would be one way I think we could handle it.
my recollection of the discussion that we had with the working group was that it would eliminate the gotcha, which both, and it was funny because both Eric Duster and Mark Brewer said substantial compliance would eliminate the gotcha, which each of them, having been having been the recipient or representing somebody who was gotten,
The recipient and the
right.
aggressor.
Right, both sides, thought that it would be, that this would be a real advance. And fairer, and would eliminate that opportunity for gamesmanship, which is something I think that you mentioned.
I mean, for me, I wanted to at least voice my concerns. It's not, I'm not a like hard line, like this is what we have, like I'm against. Addressing the motion, I do find it kind of fun that the two members that were not part of the work group are the two members that are like, we're a little more like, whoa, wait a minute. But because we weren't, I mean, obviously we're not in the room, but I can hear, I can hear that that's going to be what they're going to say. Like, they don't want to have the gotcha, which then never's, but anything that comes in front of us is going to have that kind of level to it, right? Like here's a petition, you're going to have one side that likes the petition. You're going to have the other side going to find fault with the petition, whether it's, the union bug, the font size, like, okay, I can go through a whole litany of everything that we had. The circulator's not in the right position, but I also want to make sure, I'm also want to make sure that I understand where the Bureau's at too. So I don't want to be but that's, I just need it to be public that, this is where we've sat. I know I've taken this position a lot of times of like, this is a legal document, make sure that you read it. But I also am like, make sure that you follow the directions. Like, I've been very, very vocal about that. And I know that it's heartbreaking. I know it is. But you're running for office. There are things that have to be done. So how we amend this motion, I mean, but that's kind of.
Want to create a substantial motion, right?
Kind of.
Is there
A material amendment.
A material.
Adam, you mentioned that you could in effect play with the wording on, it really comes down to what the definition of substantial is, doesn't it?
Yeah, I think that's based on the conversation I'm hearing, that's kind of, it comes down to what is, I'll use it, material versus not, like, what is that? What affects the ability for a voter to sign the petition and understand what they're signing and understand kind of those elements of what they're signing versus what is that item that maybe a voter, like if it wasn't there, the voter would still get it, again, like not talking about, or not even the voter, the circulator as well. You've got circulator warning statements on there that say very specific things that warn them that if you do X, Y, and Z, there could potentially be like felony issues or misdemeanors. Like, I think those are probably important, versus like some of those other non-material. So that's at least what I'm hearing the board say.
Yeah, and I think to kind of further address that, I think there's two different approaches we could take. I mean, one is we could take a crack at the draft legislation and put some language in there. I will say that any language we put in there, of course, there'll be discussion about what that means, which is something that, the legislature has to contend with, and the courts and the board and any other entity that has to interpret a statute. So we could put some language in there, some suggested language about what substantial means, or another thing would be to just kind of flag it for the legislature and conveying it that says that the board, the board believes the legislature should define some parameters for substantial compliance.
I'm afraid I'm not, I'm sorry.
I mean, they're going to do what they want to do anyway, but I think if whatever level of detail the board wants to convey to the legislature, I think they will take that certainly under advisement, but I'm not sure how much it'll matter whether there's detail there or not.
Can I ask, like, I'm gonna say the dumb question is, can we go to substantial if we were under strict compliance by the courts?
Yeah, I mean,
I'm,
yeah, I mean, I'll say, Heather can correct me. I mean, the courts were interpreting. My understanding is in that case, and others here know it better than I do, but
Yeah.
they were interpreting a section of the law that didn't specifically say whether it was strict or substantial and decided it was strict. And so the legislature would then say, no, it actually is substantial in this scenario.
They were interpreting the word shall to mean must. But it was a really difficult case. Because it was the nitpickiest of cases.
Mhm.
It was, it was simply a ridiculous argument about what 14-point type meant. And the court was clearly split, and the decision, 4 votes for the particular decision saying, yes, the petition is strict. 4 votes said the petition strictly complies. Some thought that it didn't. So it was something that the court had great difficulty with, because clearly there was a majority that did not want to reject the petition based upon what typeface meant. So they cobbled together the positions of the various justices and said that you have to have strict compliance, but this strictly complied. And it didn't make a whole lot of sense. And it was an argument that should never have been made. But I don't think that it changed much in terms of what the board did or what the staff did with regard to petitions. Previously, the discussions were whether something complied. It was a substantial compliance practice, even though the language in the statute said shall. You know what I mean? I'm not being very articulate here, but the practice really didn't change much. It was just that you argued about whether it complied or whether it strictly complied, right?
Mhm.
So there was always an argument about whether it complied, whether you used the term substantial or strict. And there always will be that argument.
Mhm.
And I think that it is a question of materiality. So if we had something that simply, if the legislative change, if they wanted to define what substantial is by saying material, or if we wanted to just kind of, we could come up with, Adam could come up with something. Putting the term material into the statute so that people know that this has to be, that they have to do everything that the statute requires, but if they make some immaterial mistake, that it won't necessarily come off the ballot. I mean, that's people. Now, I understand what you're saying, Jeanette, about people having a responsibility to do it right.
Mhm.
And that responsibility to do it right was certainly something that we saw with regard to the petitions that had forged signatures, right? I mean, these were petitioners who brought these numerous petitions to us when they hadn't done it right. They hadn't done the work that they were supposed to do, even though, without regard to strict or substantial compliance, that there is an obligation on the part of petitioners, whether it's nominating petitions or initiative petitions, there is a responsibility.
Mhm.
But we also have a responsibility to be fair, I think. And that's what we have grappled with, is the question of fairness. Because we have rejected petitions which had immaterial mistakes.
My apologies.
And I think that that's what we're trying to avoid. Rejecting petitions that have immaterial errors, or, I'm not even sure if they're errors, but
I guess where my concern is that it's not always going to be us on this board.
no,
And
let's
what,
hope not.
what what does that look like when at that point you could have the gamesmanship be on the board? Not on that side, but on this side. And then now you have litigation where now the board has to be represented. Now it's going to court. And now the board has to be represented because of something that's happening here on this side of the petition, not theirs, not the candidates, but this side here with these 4 members of this board.
The hope would be is that with 4 people on the board, there would always be reasonable discussion and reasonable decisions. I mean,
I know.
because the word substantial can be argued, but so can the definition of the word strict.
Right.
And we have argued that.
I still do. All the time.
Would, by keeping this in here and keeping it in here the way it is, to play to Director Brader's comments, the legislature is going to do what they want to do anyway. So they would in all likelihood pick at that a little bit and probably add some wording or take some wording away. That's the assumption.
That would be my assumption, yes.
And I know that there are others who are looking at this petition language. Who will have comments as well. They will be speaking to the committees which are considering this. And probably Brewer and Dunster will be there.
Mhm.
Is this a material enough change in the process that it would generate a lot of interest? I mean, when we discussed it in the working group, we had people who were very much with the idea that substantial compliance would provide a fairer process. Again, those were for the most part attorneys who appear before this board.
It's hard to predict. I think this would mostly be an issue that's of interest to experts and practitioners and, politicos and such. But you never know. I mean, any issue that involves elections in any way can always become a major point of interest. But I would expect that most of the substantive contributions to the discussion would come from some of the people that we know and deal with a lot, because they're the ones that would have the most specific and detailed interest in the matter.
So to maybe break the small log jam here on this, us doing this motion is meant to help the process along and indicate to the legislature that we are, as the board who deals with this stuff regularly, we're supportive of these changes, and that is meant to help the legislature move along and do it appropriately. Again, they can do whatever they want. They've done a lot of things over the last year I very strongly disagree with. And so, I'm comfortable with a motion moving this along if it did indicate, the issue of substantial compliance requires additional, requires further discussion and consideration, and then we provide some on a cover letter or whatever, here are some things that would be helpful to that process. Because I think that it puts us on record too of that this, we support the vast majority of this without qualification, but on this one, it needs some additional work. And here are some ways to make that easier.
So Adam, you would be the person taking this to the election committee. Am I correct? I think that you are Director Brader, but
Yeah, because it's for the board, so it was something we would handle, I think. Yeah, so probably Adam would be the person, yeah.
so the discussion that we're having is one that would be presented through our staff.
And that's part of the second part of the motion is like that quote unquote authorization. Just to so that way, like, we can act on your behalf, basically say, well, this is what the board wants, this is what the board said, and just kind of have that communication back and forth.
Yeah, and we definitely want to be able to convey the board's will
Mhm.
to the legislature and make clear it's the board. That of course, other people may weigh in on this. The Department of State may have, views too, but we want to be clear that what we're presenting is on behalf of the board. So that would be helpful.
And then unrelated to this, I'm just going to be really annoying. In reading through this, I noticed that there were numerous changes of shall to must, but then I found a couple where it doesn't do that. And so I assume that's just I know you didn't write it, but
So the shall to must issue is something LSB is, so I can flag them to see. I don't, to be honest with you, fully understand why sometimes it's shall versus sometimes it's must.
my
that
guess
is
is it's
an
probably
LSB.
something they've started in the last
It could be.
handful of years. And so as they open statutes, they're making the change, but
Yeah, and the draft that I initially did, I might have even missed them. I was trying to change it just because I know LSB is changing a lot, if not all of them, to must. Yeah, I was trying to remember which way to go.
yeah, from shall to must. Yeah. Yeah, it's not holding me up on anything. I just wanted to point it out.
Yeah, there's a very specific reason, and even if like I missed one, LSB will. They're very great at that things like that, catching it.
Well, you want me to make a stab at a motion here?
You
Please do.
want to modify the one that's there? Or do you want to?
Yeah, I think I'm gonna modify, so. I move that the Board of State Canvassers support the draft legislation regarding canvassing petitions with the understanding that moving to substantial compliance requires careful consideration and additional thought as to the specifics. I further move that the board request Bureau of Elections staff transmit the proposed legislation to the Michigan legislature and inform the Michigan Department of State that the board seeks the department's support of these legislative proposals.
All in favor?
Aye.
Aye.
Aye. Motion carries. Adam will report back to us. Okay. Is there the next item on the agenda is other business. Is there any other business?
Well, early voting starts tomorrow. We're excited about that. So it's going to be a very busy 20, however many hours it is, 21 hours. I think the first site opens at 6 a.m. If I'm doing my math right. No, 19 hours from now. So we will be back to certify the presidential primary results. But this will be the first statewide election that the board is considering that has early voting. So that will make its way into the canvassing process, and just wanted to alert the board to that. I think for the most part, what you're going to look at when you certify won't look too different from what you've seen in the past, but the county canvases will be canvassing the early voting ballots in addition to the election day and absentee ballots. It's also going to be the first statewide election where there's early tabulation of absentee ballots. So that will also shouldn't really have any effect on what we do, but there's going to be some changes in terms of the categories of ballots and how they're tabulated. So we're looking forward to that.
I have a question. So if just going forward, in recount situations, there will be, the question I have is, so if there's a candidate that requests a recount, is it is it now they'll have 3 categories that they'll have to choose from? So like, am I just doing in person on election day, or is it in person election day and early voting? Are they counted together? Or I'm seeing a shaking the head. So I'm curious of how that process is going to change with early voting coming in.
Yeah, so the results have to be reported separately by category. And I knocked over Mike, sorry. Sorry, Marcy. Each one of those is a separate piece of it. So, and the reason is there's a separate tabulator and a separate poll book for early voting. There's a separate for AV count boards, they're separate for election day. So if somebody wants all 3, they have to specifically say they want all 3 is our interpretation of the law currently.
Okay, so that I just wanted to have that kind of clarification, because when you come in, you could have AV or you could have in person, and now we have early. So it's a conversation I don't think that people are really thinking about now, that they know that there are 3 different categories. So I wanted to make sure I asked that for this election coming in too. I'm wondering if we have any update. Do we have any do we have any legal anything?
There is still the Graziano case, which is still pending before the Michigan Supreme Court. We had oral arguments and we're just waiting for the court's decision.
Can you update us? Which one is the Graziano again, please?
Sorry?
Which one?
Oh, goodness. It was a follow-up lawsuit on the committee to ban fracking. This was the case that was brought by the petition signers instead of the petition proponents, although it was essentially the same arguments.
Okay.
Just a jurisdictional argument. Yeah, that's it.
Else? And hearing nothing, having no other business presented to us, the hearing is adjourned.